The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as public records and freedom of information laws. The content may include adult themes, adult concepts, and adult language not suitable for all audiences. For the safety of all, no viewer should ever engage with, interact with, seek out, or contact in any way persons being discussed, including those under criminal prosecution, and especially those that state,
"It's not like I've gone and killed somebody!"
Viewer discretion is advised. Turn off your rational mind. Switch off your logic. Disassociate from reality. For in this world, BJs produce babies. Crazy thoughts produce bankruptcies and endless litigation. You are about to enter the Owens verse. All right, everyone. That's enough fun and games. I just had a mood this week. We are in a mood. This week, and I couldn't help it. We needed some Owens versus Twilight action. Twilight Zone action. Yeah, what am I trying to say here? I have no idea. It's Saturday. I shouldn't be here. I should be out enjoying the weekend, but no, I can't help it. And we're going to just go with this. Even Jeep Daddy has decided to not join me. He's out doing Jeep Daddy things. He's out jeeping, and he made some not so overt threats of, you know what, I should just kidnap you and you have to join me on a Jeep trail rather than talking about this crazy lady and her crazy family. Or as Layla from PS Creative Studios called her, Lunatic Laura Owens, or something like that. To which David Gingras, Dingus the Douche Canoe,
the fucking douche canoe,
had an epic shit fit and threatened to sue her and all sorts of other stuff. We might touch on some of that today, but otherwise we've got lots to go on. Yes, I know. Wallace is saying, boo, Jeep Daddy. You can lodge all your complaints, Wallace, on his channel at Off-Road Entropy on YouTube channel. It's like, what are you doing being out in a Jeep rather than talking about this? How dare you, sir? How dare you? I don't. He's probably listening right now. He might even be lurking in the comments. You never know with that guy, even out on the Jeep trail. So it's nice to see you all here on a Saturday. Hi, Wallace. Hi, Bruce, who says "yar" as Bruce is wont to do, if it's not some other pirate speak. Robin is saying, "Hey, everybody! Excited to cover this." Yes, there is so much to cover now. And, as luck would have it, Danny's here too. I'll just derail myself. How about that? Hi, Danny. You're still at work. That's fantastic. Enjoy what is to come. And if you decide to chime in, that's fantastic. Rachel Taylor, happy Saturday to you as well. Yes, Robin, a little spookiness. Because when we're in the Owens verse, how can it be anything but spooky? Right? I know, it's just bizarre. Time does not flow normally, and it's just it's its own little thing. It's like a black hole. Mother Pugger says, echoes in the daytime, what a treat. Well, for some people it's practically dinner time, but it just depends on which corner of the universe you inhabit. Yeah. Rachel Taylor, eek, yes. No thanks. Okay, good to see you in the Owens verse. Yes, we are indeed. Brace yourselves, everybody. Brace yourselves. Mother Pugger also says 16 people in chat are fake and gay for not hitting like yet. Okay, as a gay person, I will snicker at it. I can't help it. Bitch Tits says, evening from Blackpool, UK. Evening to you as well, from not Blackpool, but almost opposite corners. Horse girl, purpose. I can't read all those words together. Purposeless people says horse girl. See, that's what happens when we use names and they're all just a string of words. And those of us who have to read them live going, okay, where's the dividing line between all the words? Dana Creasy says, happy weekend, everybody. Good to see you, Dana. Marilyn Leo is here. Hopefully you have fun plans later. I've got some plans, modest plans, perhaps. It's supposed to do a little bit of raining over the weekend, so it's like not purposeful plans. I did get my hairs trimmed today, as sometimes happens. Karen O'Hipster, howdy ho. Howdy ho, neighbor to you. And Madam Vanderfloof is also present here as well. Good evening and afternoon to all of you, as your time zone so dictates. Okay. There's so much. And this is what happens. See, a week plus. What was it? It's been, last Thursday, Friday, Saturday. More than a week. 9 days or so since our last convergence. Since the last great conjunction on my little cubbyhole on the internet. The last great conjunction of the Owens verse here on this channel. Oh, some things have happened. Some things have happened, haven't they? And Ducky, nice to see you too, Ducky. Eleanor is also saying evening from Scotland. Greetings to the UK, Scotland, Ireland, all the other British Isles, or as some may say, we don't want to be referenced as British Isles. Never mind. I still have a British flag that slightly burns in my heart genetically anyhow, as well as behind my head. It happens. It happens. If I had a little bit more immediate, no, that's not the word. Immediate separation, that doesn't work, does it? Well, I have close relatives that hail from the Isles of the United Kingdom. So, I have a glowing light in my heart for the British Isles, whatever it may be. And Llama is here as well. Hello, Llama. And Toadette. Greetings from the Netherlands. Oh, see, I didn't know Toadette was from the Netherlands. I have learned something today. I have, and it's shocking on a Saturday because I just try and turn the brain off, especially when I talk about this stuff, because you can't survive talking about anything with Laura Owens, David Gingras, or, really, any of the Owens family if you keep the brain engaged on too high a setting. It doesn't work. You will find yourself in such cognitive dissonance. You will smell burning toast and you'll think you're having a stroke or some such thing. It's just crazy because that's what talking about this for any length of time will do to you. It's just so nuts. But now we have to remind ourselves, these people, that being the Owens family in general, and ancillary, how do you say that? See, now I'm having problems with words. Ancillary members like David Gingras, because he just seems to, fraternize a lot, as he says with Laura Owens. Oh, yeah. You can't be too rational when you think about this stuff. Katie Pillar says, we need Big Tiff Dog to explain if this Chapter 11 is to address the LLCs and their owing taxes to unpaid CEOs. I have some thoughts about that, but yes, I'm sure any day now, Big Tiff will be talking more about it, because those of you who follow Tiff will know that she has stated in her very thorough analysis that if the Owens family, that being, shall we say, Jan Black, Elizabeth Ann Naylor Owens, and her poor husband, who I think is just incapacitated to the point where he has to go along with the feminine wiles of two crazy women that live under the roof that mostly is his career is paid for. And even Bruce. Bruce is still present. He's popping in and out of chat. Ahoy, yar, Sir Bruce. Or Sir Moose. Sir Moose the Bruce. That works too. But anyhow, with Chapter 11 stuff, let's go right to that. You know what? I could just, I could prattle on forever, right? Ms. Wing says, Owens family have to travel to CA soon? Not for a little bit. They have kicked the can down the road. So let's talk about that, shall we? Let's talk about it indeed. Oh my goodness. So the breaking news. Breaking news yesterday was that, not to anyone's surprise, I don't think. I just sort of snickered, went, yeah, of course they did the bunch of frauds. Because I believe they're frauds. I believe they're engaging in fraudulent behavior. They're certainly not wanting to pay their bills, and they're certainly not wanting to, how shall we say this? File things in good faith. Because, here's the thing. Here's what's happened right at the conclusion of the Chapter 13, which, got dismissed because they didn't file their taxes properly with the courts. The court wanted some information. They wanted their taxes. And of course, because mommy and daddy allegedly have not filed their taxes with the IRS in at least, I believe I saw 2 years, they would have to get caught up on some legitimate tax filings, number one. And number two, those legitimate tax filings would have to be shared with the bankruptcy court while the Chapter 13 was still viable, which they did not do. So what did that result in? The Chapter 13 bankruptcy for Ron Stephen Owens and Elizabeth Ann Naylor Owens, a.k.a. Jan Black, was let go. It was dismissed, which made them liable for all of their spending habits, shall we say, for all their indebtedness, for all those things. And guess what? Guess what, folks? That resulted in the bank, who owns the house and messita or casita, depending on how you like to look at things. If you look at the body cam footage, it's the messita with piles of clothes and dog stuff and such. Yeah. So if you take all of that and look at the indebtedness and the fact they hadn't paid on their mortgage for quite some time, the bank was going to foreclose on the property. And it was being placed up for auction at the courthouse in, I think, Phoenix, as memory serves, the day after Memorial Day. So that being Tuesday. So, it was sort of my running joke that, a bunch of people should get together and buy it out. Go to the auction, go buy the house. Maybe turn it into a museum. I don't know. Do what you will with the thing. Turn it into a Airbnb. Clayton probably could set people up with that thing. Do something with it because this story is not done yet. So to avoid and to delay the inevitable, which is, par for the course with the Owens family. Delay the inevitable. Delay, litigate, delay, stall. They filed for Chapter 11 this time at, as it says in this document, let's see, let me scroll down. This is on the JFC Reddit. For those of you interested to know, all of the source material for this afternoon and evening is listed in the show notes in great voluminous detail, as are things like this funny little QR thingy up above my head, if I'm doing this properly, because of the way cameras invert things. For Mike Marraccini, as also is, oh, you know what? Darn it, I forgot to turn it on. I was thinking too many technical things with the introduction that I just wasn't paying attention. So let's turn this one on too. There's the thing down below for Mike Marraccini. If you want to give to Mike Marraccini, I've also listed in the show notes, and because I can only have one thing at a time, I've just decided to keep going for Mike at this point in time. But you can also, if you're feeling so inclined, to give to Hey Rob's Give, Send, Go. I found the link for that at long last for Rob. If you feel so inclined to give to Rob and all of the nonsense of his poor injunction case that did not go well, and he's got, now he's got to pay douche canoe.
The fucking douche canoe.
Yeah, he's got to pay his defense attorney some $31,000 in douche canoe, some $1,800 and change. So, Rob's got some bills to pay there. So, depending on where you feel generous, you may wish to donate to either of those, one and or the other, as you so see fit. So there is that little tidbit of news. So, all right, back to the bankruptcy. See, this is why I need Jeep Daddy to derail me. It helps me collect my thoughts while he's on a Jeep Daddy tangent rant. And then I can, kind of put myself back together. Oh, it's just crazy. Julianne says, light mode on Reddit is crazy. Yeah, I know. I've got everything set to dark mode on the machine, and this is just how it displays. Sorry, I prefer dark mode. Everything else I've got up is, well, as it defaults to dark mode. Ducky says, Bruce the Moose is a pirate. Yeah, he certainly seems to be. The Yars and the Args and the whatever else. If Bruce decides to do other pirate things like plundering of booties, that's a different conversation for another day. And I think I would want Jeep Daddy around to have that conversation. Sherry says, these people, exclamation point, a family of cons, don't sue me, please. Well, when they seem to keep filing for bankruptcies at least from my vantage point, and certainly based on the analysis by Big Tiff Dog, seem to be frivolous at best. I think calling them cons is not beyond the realm of logical pursuit. Yes, I know. I said in the introduction with great reverberation, turn off the brain, turn off the logic. That's how they think. Now, it's okay if we try to think with a little logic because, well, if we refuse to live rationally in a rational world, we're all in trouble. We're all in trouble. It's just crazy. Michelle, hello, echoes in chat. Nice to see you, Michelle. Dana says for the X types. Oh, and that's I think that's Dana's X information. 1940s grandma's IDs as married to Ballard. Always made me laugh. Set up Twitter with a name to read articles in 2018. Too boomer to sync X and YouTube. I know it's terrible, isn't it? I've made that blunder myself, Dana, and I can't quite claim to be a boomer, even though I'm starting to do boomer-like things. He set some things up with the best of intentions, and at least in my case, some of those things shift a little bit, and then you go, well, why did I set it up that way? That was stupid. Jen Adams says, are any of us surprised? Nope, absolutely not. And I will use LY words for that. Sea of Thieves calls, says Bruce. The Scam Fam says, no thanks. Okay. Jennifer C says, well, to be fair, they are morally bankrupt and there's no amount of money that will fix that. Oh, that's pretty good. That's pretty good. Jen Adams says, can't wait to see the train wreck this bankruptcy is going to be. I know. And because it's so fresh, we don't have all the details, right? It's just insane. There's going to be more paperwork to read, other things, other appearances, which will be entertaining for us. The Owens family just cannot help but give us a constant stream of content and stuff to discuss. But that is their folly. That is their folly for continuing on where it's just ludicrous to do so, but they can't help themselves. So I'm going to read a little bit of this as well, because some of the stuff here in the GFC, outline and such is worth reading. It's interesting information. We've got lots of other things to cover today. But let's see, how fast can I get through it by myself? That's the perennial question. And this was last updated May 22nd of this year, 2026 at 4:11 p.m. The United States U.S. Bankruptcy Court in Arizona, District of Arizona, assigned to Madeline C. Wensley. I assume that would be the bankruptcy. Is that the bankruptcy judge, I guess? Citation Elizabeth Ann Naylor and Ronald Stephen Owens. Yikes. Date filed May 22. Of course they would file Chapter 11 at the 11th hour on a Friday of a holiday weekend. Of course they would. So let's see. Where's my other? Oh, there we go. Let's switch over to this one because we've got some other little tidbits too along with this. So there's 3 docket entries as posted on the JFC Reddit for the case number 1, Chapter 11 voluntary petition for individuals filed by Elizabeth Ann Naylor, Ronald Stephen Owens. I'm sure it was mostly Elizabeth Ann Naylor, aka Jan Black, and a little less Ronald Stephen Owens, but that's just my assumption. The second entry is a meeting of creditors is scheduled. So write this down on your calendars, folks, for, oh boy, June's going to be busy too, for June 30th, 2026 at 9 a.m. as a Chapter 11 teleconference. And there's all the details for calling in, apparently, and all the requisite things to be a call-in. So if you happen to be a creditor for the Owens family, I would imagine you have every right to be there and ask questions if you are such a creditor. If you are not, that's a different thing. And I would imagine public can listen in as well as listen quietly and not interrupt because it is a court proceeding after all. But I don't know all the ins and outs of such things. So take that with a grain of salt. As I recall with the other bankruptcy things, lots of people were calling in to listen and record or do other things as some are wont to do. We'll get it eventually when it all happens. So when it hits the internets, we'll cover the details as they trickle out to us, of course. And item number 3 They are ordered to immediately pay a minimum $80, I assume that's a filing fee, and a balance in 3 installments, signed on 5/22/26. Minimum $80 fee due by 6/5. First filing fee installment due by 7/6. Second filing fee by the 31st of July. Final filing fee due by 8/28. That's interesting. That's interesting to me. Absolutely wild stuff, isn't it? So there's some things there. Let's see. I'm going to click on this and let's go back over here. But there was those couple images attached and I wanted to hit on those because it's interesting. And we like things that are interesting. So let's see. This is again from the JFC Reddit. Updated. We like this. The story is still developing. Of course it is. Of course the story is still developing. We need some mysterious music because it is under development. The TLDR. Today, May 22nd, Ron Owens and Elizabeth Naylor, Jan Black, filed for emergency individual Chapter 11 bankruptcy to freeze the upcoming Tuesday, May 26th foreclosure auction of their Scottsdale home. Crucially, they filed pro se. God, how stupid. How stupid. Because Monday is Memorial Day, courts and banks are closed, but their Friday electronic filing instantly triggers a temporary 30-day automatic stay that stalls the sale, or we should say the auction sale. However, because their previous Chapter 13 was substantively dismissed in January for non-compliance in January, and administratively closed on May 11, they face a steep legal hurdle to prove this new lawyerless filing isn't just a bad faith delay tactic. The court has already ordered an installment plan for their $1,738 worth of filing fees. Yow. That's a couple zeros in that. See? Filing for bankruptcy costs you money, folks. My God. Let's see. Okay, yeah, the court has already ordered an installment plan for their $1,738 filing fees, of which they haven't even paid the first due today, and set a creditor meeting for June 30. So I wonder what happens if they don't even pay the first one. Is the court going to just toss it? What's going on? Oh, let's see. Mother Pugger says, she filed it because her name is first. Yeah, and she does all the dirty work, at least in my observation. Wallace says, I think she owes us all money for our time now. Oh my God, we could have said that a year and a half ago. I've been covering this thing for 2 years. My God. I'm breadstick money for future therapy. Julianne says, at least $350. Okay. Let's see, what is interesting to you about the dates specifically? What interests me about the dates is there's going to be more case management stuff happening in the end of June. Someone's, I'll just tease this now. Someone's plea deal was extended to June. We'll talk about that. We'll talk about the criminal case coverage of Laura momentarily. Jen Adams, the Owens, in air quotes, bad faith family. I would say that's an understatement. Yeah. Oh, let's see. The court, okay, set a creditor meeting. All right. The looming action. Can Ron and Jan's emergency individual Chapter 11 actually save the Scottsdale house? Some of this seems almost like AI stuff, but that's an assumption too on my part. Maybe it's not AI, maybe it is. When I see the emoji images, I start to think AI. That's okay. We'll read it nonetheless. Many people assume that filing for bankruptcy is an automatic get-out-of-jail-free card to stop a home foreclosure action. Well, someone thought it would stop a judgment debt against them for their stupid paternity action, for which they're racking up lots of fees with interest over $200,000. There might be some sort of mental deficiency where they think filing things in court automatically, is a get-out-of-jail-free card, so to speak. Oh, let's see. Because it was dismissed earlier this year, that being the Chapter 13, today's emergency individual Chapter 11 filing puts them in a complex legal minefield. Oh boy, does it. We are here for it. We're here for the popcorn that we get to ingest while watching yet more Owens shenanigans unfold before our very eyes. With their Scottsdale home scheduled for auction on Tuesday 26, Here is the reality of what this brand new filing actually accomplishes, what the court is already ordering them to pay, and why doing this pro se makes their chances incredibly slim. Yeah, it seems like AI. I think this is. It's not a judgment to anyone posting it on JFC. It's just, it's interesting. I think it'd be great if it is AI generated commentary. It would be nice to know that, just for thoroughness. Those of you who've been here a while know that Jeep Daddy, being the brainiac IT infosec guy he is, working for Corporate Daddy, he talks a lot about AI stuff. He talks a lot about info security, all those kinds of things. I think it's nice. I think it's nice when we're looking at things like AI generated commentary. That it's nice to know that, because AI does get things wrong. And since we are reading this and hoping it's at least mostly factual, we need caveats where necessary, right? The timeline in the Memorial holiday. Trish Jax's mom says, just here lurking. Glad you're here, Trish Jax's mom, just lurking. It's okay. We like lurkers. We like regular chatters. We like lurkers. We like the replay crew. Love to everybody. There's no shortage of love here at all. Robin says they won't pay any filing fees, so when will the auction be rescheduled for? Really, Robin, that's the punchline, isn't it? Okay, this one's going to get bumped out. What's going to be the next date for the auction? Hi, Jen the Couch. Very nice to see you. User QQ etc. I'm not going to read all that. Says, turns out the house is worthless. Oh, sorry, I read that wrong. Turns out the house is worth less than they thought because the casita has to be burned for public health reasons. That's funny. That's funny. It's, I would imagine it's nothing that lots of bleach and professional cleaning couldn't fix, as well as, I don't know, auctioning off clothes or anything left behind. Yeah, it's sad. It's sad because, the external situation reflects a lot of the madness within. At least that's my opinion. But I say that not because I'm a neat freak either, because, well, quite honestly, my place isn't exactly the tidiest of things, but it's just me, myself, and I, my little cubbyhole. So I don't put up any pretenses to just having this immaculately small residence. All right, back to this. Because they had a bankruptcy case dismissed on January 26, 2026, which was formally and administratively closed by the court on May 11, they are legally classified as repeat filers since the active case elements happened within the last 12 months. Under Section 362 of the Bankruptcy Code, Congress put strict rules in place to stop people from repeatedly filing just to stall foreclosures. We call those serial filers. They could be serial frauds too, for all we know. It's my belief, based on the actions the entire family, at least mom, dad, and Laura, seem to engage in, I would call them serial frauds. But that's my opinion. You're welcome to read information and reach your own conclusions. Let's see, Jen says, a couple of foggers necessary in the casita. I would imagine, what I would like to see is some footage of the horse area and see how tidy that is. Is the horse stable? Is the stable? That's the word. Is the stable is organized as the messita, or is it something else? I don't know. Bruce, the pirate moose, says, I used my year off to downsize, and it was the best thing ever. Yes. Well, and when you accumulate things, especially before you move. Yeah. Before you're about to move, before you live in a tech van for a little bit, tour the countryside on the way to a new stomping grounds. You can't be burdened down with frillies, right? Minnie T says fumigation isn't cheap. No. Even if it's only a casita. Oh my God. Terrible. Let's see. All right, the holiday factor, because Monday is Memorial Day. Happy Memorial Day weekend, everybody. The bankruptcy court, the lender, and the foreclosure trustee's office are completely closed. You know what's funny is, because no one's going to be in on Tuesday, as if there will still be an auction held. See, this is what I don't know. I don't know how this works. If someone's going to show up Monday morning, be ready for an auction, go, oh, well, crap. Now we can't do the auction because we just got this late 11th hour thing. Well, not even 11th hour. It's like 12th hour. They're filing bankruptcy again. I don't know. I could see a number of scenarios, and I know nothing about bankruptcies and bankruptcy court because, of course, I don't practice in such things. But wouldn't that be funny if it carried on nonetheless because of the holiday, and it was despite their attempt to slip one in to buy themselves more time? I don't know. I don't know the technicalities. We need a bankruptcy lawyer. Is anybody in chat a bankruptcy lawyer? That would be great. Jen the Couch Fray asks, how can they file if courts are closed? They filed Friday afternoon. The date and timestamp, I will bring this back up just because with our slightly spooky, slightly alien background music. The date and timestamp on this thing is May 22, 4:11 p.m. So in good Laura Owens fashion, it must be a genetic thing. It must be a family thing. Filing something before the court closes right at the end of day. Yeah, that's what they did. At least according to this, that's what it says. Let's see. Jen also says, Jen stood up on the black chair and shouted, I declare bankruptcy. That lady should not be climbing up on any sort of ladders whatsoever. No, she should. I have a feeling she's a little bit fragile. The black chair. Thank you, Minnie T, for that. All right, back to the other one. Dangerous. She's not a spring chicken, that lady. She should. You know how dangerous it is standing on rolling chairs? My goodness. If you fall off, you might break your neck. It's a safety hazard. She shouldn't be doing that. Just like Mother Owens should not be riding horses, because if she fell, that could be catastrophic. People need to be safe. They need to be healthy. They need to do things to preserve their health and safety. And I don't know, I'm starting to get a sense. There's a certain recklessness in the Owens family when it comes to health and safety. But that's just my observations. That's opinion based on observations. We don't ever seem to go to real doctors with real appointments for much of anything. Even for fake twins. So what do you do? Oh no. Ducky says, pray for me. My daughter is driving me around for errands. Oh, Ducky, bless you for that. I don't have to worry about such things, thank God. I'm not sure my heart could take it. My mother, bless her heart, may she rest in peace, would always sort of cling to things in the car. Even with my father driving, she would get on his case and hang on to the suicide pole and just kind of brace herself and stop driving that way. Oh, Jen says, practicing for the license. Yo, very test is Thursday. Oh, lovely. See, rites of passage. Isn't that wonderful? CLTD, OCMD. See, I can't make that into a word. Jan is the same age as me. No way am I standing on the black chair. It rolls. Exactly, CLT. Exactly. I don't even like being on black chairs myself, whether or not they roll. Oh, it's not that I'm prejudiced against black chairs. It's just, I don't have any. Actually, that's not true. This is not a rolling black chair, but it is sort of a dining room chair that I'm sitting on currently. Jen says I'm hard to rile up, but could not drive my kid with my kids learning complete panic. Let DH do it. What do we call that? Abrogation of parental duties. I don't know. Safe journeys and adventures. Indeed. No. Okay. See, I tried. I'll just say CLT. It works for me. That could be as good as a BLT, and we like BLTs around here. Heavy on the bacon. See if I can conjure up bacon bears. Where were we? Okay. Good news for them. They get a temporary automatic stay the exact second the electronic filing went through today. Because this protection is immediate and automatic under federal law, the auction cannot legally move forward on Tuesday morning. Well, drats. Even with the holiday shutdown. Oh, double drats. Double drats. That deserves one of these. All right, maybe I'll give the background music a rest for a minute. The bank cannot sell the house on Tuesday unless they rush to court Tuesday morning for an emergency order, which is virtually impossible to pull off. Yeah, they probably won't. It is holiday weekend. New court orders the cost of Chapter 11 Chapter 11 is notoriously expensive and complicated because they file pro se, and the court is going to hold them to strict professional standards. Oh, well, duh. Yeah, this must be AI generated. The court has already put them on a zero tolerance payment schedule to pay off their 1738 total filing fee in the installments. If they miss a single one of these deadlines by even an hour, the court can instantly dismiss the case. Really? Interesting. So there's the breakdown of the schedule for the filing fee installments. July 6, July 31, and August 28. Oh, this is so fascinating. It's nice to have dates. So look, more dates to put on your calendar to keeping track. The Arizona Advantage, Ninth Circuit rule. What is this? What? Federal courts across the country are heavily split on what happens when the 30-day clock runs out. Fortunately for them, Arizona falls under the debtor-friendly Ninth Circuit majority rule. When the 30 days expire, the state only lifts against Ron and Jen personally. It does not automatically lift the house itself, which is considered property of the bankruptcy estate. This means the bank can't just sit back, wait 30 days, and hold the auction. The bank's lawyers must formally file a motion for relief from the stay and convince an Arizona judge to let them foreclose. I suspect we'll see such filings. The individual Chapter 11 trap, why 13 fail. Their previous Chapter 13 case, which was substantively dismissed on January 26 for non-compliance, and it relates directly, double M dash, yeah, okay, so it's AI, fine, whatever. Caveat emptor, AI-generated commentary here. And it relates directly to their corporate entities, including Quartet Farms LLC and Lizmax Investments LLC. In a Chapter 13 bankruptcy, an individual set up a personal repayment plan, but it comes with a strict debt ceiling. Because their personal mortgage and secured debts likely exceed that individual cap, they were forced to step up to a Chapter 11 filing. Well, they weren't forced. They chose to, right? They chose to file Chapter 11 after the Chapter 13 and Laura's Chapter 7 boondoggles failed. This seems to be just more deny, delay, stall. While the official court records confirm, let's see, did I read that? Yeah, okay. While the official court records confirm this as a Chapter 11 voluntary petition for individuals, do not let the word individual fool you. Under the law, an individual Chapter 11 is still forced into an incredibly heavy business reorganization framework. Unlike Chapter 13, personal repayment plan, an individual Chapter 11 treats the debtors like a business entity. It demands brutal forensic financial tracking, mandatory monthly operating reports, separate debtor in possession bank accounts, and heavy creditor oversight. They are essentially forced to run their personal finances with the strict regulatory compliance of a corporation. Ooh, that sounds problematico to me. Paging the IRS. Internal Revenue Service, please, to the Arizona courthouse. And while we're at it, paging Queen DOJ Jennifer. Queen Jennifer. I don't know if Jennifer can enter this thing or not, but wouldn't that be funny? Wouldn't that be something else if we saw more bankruptcy trustee involvement? And even this one, I was under the impression in some of my earlier research from looking at some of this earlier, I was under the impression that it would be less usual in a Chapter 11 to have a trustee get involved so often. However, they are not precluded from doing so, especially when in an oversight capacity, and especially if there could be suspicion of fraud. So it's not entirely impossible that we won't see some oversight here as well. Oh, let's see. Desperate Freya says, if a debtor fails to seek and obtain the extension of the stay within the first 30 days of the filing, the creditor will file a motion to confirm that the stay is not in effect. That's what happens. Oh, excellent. Thank you for the information. Dun, dun, dun. No thanks, MK. The Gamble the Pro Se Nightmare for Chapter 11. Shifting to an individual Chapter 11 after a prior dismissal within the year triggers a legal presumption of bad faith. Is that true? I think that could be true. It certainly triggers a presumption of they need to look at it closely. Assuming the debtors are using the courts strictly to delay a bank. While the 4-month gap since their January dismissal gives them an arguable defense to say circumstances changed, executing an individual Chapter 11 reorganization requires intense legal maneuvering. To keep this case alive past the 30-day mark, they must present clear and convincing evidence of a real change in financial circumstances, which, as far as I'm aware, haven't happened since since the Chapter 13, such as concrete plan to market the Scottsdale home for sale or a newly stabilized financial structure. How about kicking Laura out of the house, making her get a job, and live on her own? That might be a good concrete plan for financial reorganization. Oh my God. Trying to navigate the massive disclosure requirements, monthly operating reports, and corporate-style legal heavy lifting of an individual Chapter 11 without a lawyer makes it highly probable the U.S. trustee will move to dismiss or convert this case very quickly. Ooh, we like that. Well, hi, Tony Murray. Good to see you. Happy Catterday. Oh, indeed. Oh, thank you for that. List your felines below. We like Catterdays around here. I don't have one currently, but I wish I did. And smooches and hugs and kisses to everybody else too. Oh, let's see what happens next. Because Monday is a holiday, today's electronic notice of the bankruptcy filing is already sitting in the lenders and auctioneer systems. Oh, boo. 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 However, to prevent a rogue trustee or auctioneer from mistakenly proceeding with the sale on Tuesday morning due to communication lag, Ron and Jen will have to act as their own legal team. First thing Tuesday morning, they will personally need to ensure the bank's foreclosure attorneys and the local sheriff's office have confirmed receipt of the new Chapter 11 case number, so the auction is officially taken off the block. Well, that's going to be some quick maneuvering, but, they like to call the police regularly, don't they? Don't they? They like to call often. They know that phone number for the Scottsdale police like the back of their hand. They probably have it in their phones even, would be my presumption, or they have it memorized. That's wild to me. No thanks says, it was dismissed because they didn't follow the requirements. Now they refiled last minute. How many times can they pull this? Until the courts shut them down, I think is the answer. Just like Laura had to sign a required stipulated motion that she wasn't allowed to file for a year. Things like that can happen here too, as can some other penalties. That's very interesting. Hellville here. Oh, bless it. I can't read. It's a problem. Good to see you, Hellville. Hi, friends. Catching up, continuing listening on the way to meet up with Lethal Lauren. Oh, well, say hi to Lauren for all of us here, talking about the latest developments. I was going to say gossip, but it's not gossip. It is the latest developments in the Owens verse. Oh, my gosh. Tony Marie, what a bunch of effing grifters. Yeah, so true. So true. Wallace says, I watched Nick Starr's video on this. I did too earlier, 8 minutes worth. And he said, get ready for last minute bankruptcy to be our new normal with the Owens. Owens is. Yeah. It's a delay tactic. Right. Tony Marie, I can't believe they can do this. It's so freaking obvious what they're doing. I can't believe it isn't illegal. Well, it can be when the court decides they've had enough. K-Dubs says, nice to see you, K-Dubs. Oh, no, I'm late. Nah, you're never late. Everyone else is simply early. Have fun, Hellville says, well, so let's see. Desperate Freya says, the sheriff has nothing to do with this, and Tiffany and Bosco probably already knows about the filing. TNB will postpone the bankruptcy for about 30 days to see the TS. Oh, yeah. Okay. The TS for 30 days to see what happens. Okay. Trish checks his mom. Police on speed dial. I would suspect. Thanks for Big Tiff Dog for breaking the story with the help of CM to hear how they handled court procedural expectations and questions As you can listen to Ron Owens and Elizabeth Ning bankruptcy hearing. We've listened to the hearing. Edited to add update on official timeline documents. Ooh, we like edits. We like more information. The official court records show that the U.S. bankruptcy judge Paul Salas signed the formal dismissal order on January 26. Case was dismissed because Ron and Jan completely failed to comply with the Chapter 13 trustees' recommendations from December 2025 and failed to file a valid plan confirmation order. While the court docket was left open for administrative accounting until its final closure on May 11, the substantive legal dismissal date was January 26. Because this dismissal occurred within the past 12 months, they still are legally classified as repeat filers. This means the automatic 30-day automatic stay restriction is in full effect for their new filing, and the legal presumption that they're acting in bad faith to stall the bank still applies. Furthermore, filing pro se introduces absolute logistical and legal nightmare that makes long-term success highly improbable. We're here for this. No leeway from the court. Federal bankruptcy courts and U.S. trustees hold pro se litigants to the exact same standard. Yes, we know this. They won't receive any extra things, blah, blah, blah. Missing a single required financial schedule will cause immediate dismissal or some other things. LLC corporate trap. Under federal law, individuals can represent themselves, but individuals cannot represent corporate entities or LLCs in federal court. Ooh, that's interesting. I didn't know that. Since Ron and Jan's financial issues are heavily tied to corporate entities like Quartet Farms and Lizmax, they hit a legal wall. They cannot file motions, respond to objections, or represent the interests of these corporate entities without a licensed attorney. Ooh.
Gotcha, bitch.
Gotcha, bitch. Fascinating. If the court determines the Scottsdale home or the related debts are legally entangled with their non-individual business entities, their pro se status could cause that portion of the case to be thrown out almost immediately. Ooh. Administrative burden. The individual Chapter 11 framework requires strictly monthly operating reports, separate debtor in possession bank accounts, and complex biweekly financial disclosures to ensure the debtor isn't hiding or wasting assets. Managing these forensic accounting demands without legal counsel typically results in compliance failures with the first 30 to 60 days, giving the bank an easy opening to lift the stay and proceed with the foreclosure before they've even hit their mandatory meeting of creditors, June 30. Ooh, okay, folks. Order your popcorn now. Order your popcorn now, folks. This one's going to be a fun one to watch. More fun than the first one. I thought the first one, the Chapter 13, was boring. Especially when they didn't do anything. It's like, oh, this is boring. This is legal maneuvering to stall. I'm bored. Ugh, wouldn't you know? So there we go. There's some stuff with bankruptcy. Isn't that fantastic? Isn't that fantastic? Oh, let's see. They bought the house furnished, says K-Dubs. They don't even own the furniture. Yeah, I suppose that anything that wasn't their property, because, we know a lot of their property is in storage, very expensive San Francisco storage for whatever reason. And they're paying lots of money on that San Francisco storage. If anyone shows up for auction, Jan could pass out chocolate bars as a consolation. I'm not sure I'd trust any chocolate from that lady. Let's see. Tiffany and Bosco appears to be a Phoenix area law firm. Interesting. Very good. Let's see. Tony Marie says, I was wondering how they can file this under Chapter 11 business bankruptcy. None of their businesses make any money, and how does that include your private home? Yeah. Oh, let's see. Desperate Freya says the LLC membership is nothing more than an asset in the case. The value of the LLC must be accounted for. Nothing improper with the filing subject to extending the stay. Fascinating stuff. See, this is where Tiff has to enter the chat, and I have to bow out because it's starting to get technical. And that's just too much for me. When it gets into technical stuff involving money and numbers, I know enough for my own survival needs and what little I can put into retirement and that sort of thing. And the rest is up to much smarter numbers people like Tiff. So I will leave such things to people like Tiff. So let's go over here to this. Let's go to this little thing here. This is good. Speaking of bankruptcies, we know that Laura Owens had to file the stipulated motion for dismissal. We know that was nudged and brokered, shall we say, by Queen Jennifer, because Laura was placing herself, I believe, in extreme legal peril if she was going to try and continue on her Chapter 7 adventure. So this is the hearing for this dismissal. I have not listened to this yet. This comes to us from Schnitzel Ninja, as you can tell by the charming Schnitzel in the corner. So let's see. Let's do this little thing, shall we? Where's my play button? There it is.
Please call the matter on our 2:15 calendar.
In the case 25-11801, Laura Owens, and we do have the debtor on the phone.
Okay, I'm going to ask for appearances in the Laura Owens case. I'm going to start in the courtroom, please.
Good afternoon, Your Honor. Jennifer Giamo on behalf of the United States Trustee.
Thank you.
Good afternoon, Your Honor. Marcus Reisinger appearing on behalf of the creditor and adversary complainant, Clayton Eckert.
Thank you. And do we have Miss Owens on the phone, please?
Yes, Your Honor.
Thank you. And I understand is there anybody else who wants to make an appearance?
Your Honor, this is Christian Luters. I am Miss Owens' attorney in her criminal matter in the Maricopa County case. I'm not making an official appearance in this case. I don't think I have standing to do so. I'm not a bankruptcy attorney, and I'm not representing her in that matter. I'm here only for informational purposes only.
Okay, counsel, could you spell your last name for me, please?
Sure. Lueders.
Thank you very much. Is there anybody else who wanted to make an appearance on the record? All right. I do understand that I also have several people that are listening in and not making an appearance today. And I understand that's because this debtor has been in the news and also on social media.
Boy, the judge got that one right, doesn't she? Holy hell. Yeah, when you got a high-profile bitch case, you've got a high-profile something.
This hearing, of course, is open to the public. It's their right for them to be present today. But I must admonish that under federal law, it is illegal to video or audio record any part of these proceedings. So please do not do so. All right. Ms. Giamo, I'll let you start us off.
Thank you, Your Honor. So as you'll see on the docket, Your Honor, the debtor and the primary creditor, the largest creditor, Clayton Eckert, through his counsel, all agreed that the case would be dismissed voluntarily, and Ms. Owens agreed that she would not file a bankruptcy case in any other district for at least a year from the date of entry of the dismissal order. We have Ms. Owens' signature on the stipulated motion to dismiss, along with counsel for Mr. Eckert, and 2 days ago, I uploaded a proposed order of dismissal that was also signed by myself, Mr. Eckert's counsel, and Ms. Owens. I just want to note for the record that the signature of Ms. Owens on the proposed order is an electronic signature, whereas the signature on the stipulated motion is a wet signature. So they appear different. And I corresponded with Ms. Owens this morning to confirm that even though the signatures look different, that she did in fact sign both of those. We properly noticed out this hearing to all the creditors and interested parties on the master mailing list, and no objections have been filed to dismissal. I did correspond with counsel for the Chapter 7 trustee, and counsel indicated the trustee did not object to dismissal. I just wanted on the record to confirm 4 things, if we could, Your Honor.
Please.
So first, I just want to confirm that even though the signatures are different, I'd like Ms. Owens to confirm that she did in fact sign both the stipulated motion and the stipulated order.
Okay. Would you like to do that right now?
Sure. Thank you.
Okay. Ms. Owens, can you please confirm that for us?
Yes, I can confirm that I did sign one electronically and one wet signature. I apologize for that.
Okay. Thank you for that.
Thank you. The second thing I want to confirm is that Ms. Owens had signed the stipulated order and the stipulated motion and agreed to the terms of both voluntarily.
Could you confirm that, please, Ms. Owens?
Yes, I did.
Okay, thank you.
Okay. Third thing, I want to confirm that no other terms were promised to induce Ms. Owens in exchange for her agreement to voluntarily dismiss her case and agree to a 1-year bar to refiling.
Ms. Owens?
That is correct.
Okay.
Okay. And the last thing, Your Honor, is I just want to confirm that Ms. Owens understands that her case is being dismissed voluntarily and that she is prohibited from filing a bankruptcy petition in any U.S. court for a period, bankruptcy court for a period of 1 year from the date of the entry of the order of dismissal.
Ms. Owens, do you understand that?
Yes, I do.
Okay. Thank you.
And that's it, Your Honor. So the U.S. trustee submits that we ask the court to enter the proposed stipulated order of dismissal that was lodged with the court on Monday.
Okay.
Thank you.
Mr. Reisinger, is there anything you would like to add?
No, Your Honor. Thank you.
Okay. Ms. Owens, anything you'd like to add?
No, Your Honor, I appreciate it.
Okay, thank you. I have had a chance to review the papers prior to taking the bench today, and I also have reviewed the form of order. It looks to be in order. I found good cause to approve the motion and the agreements that are set forth therein that would bar the refiling of a bankruptcy case for 1 year, and I will sign the order. Thank you for coming in.
Thank you, Your Honor.
Thank you, Your Honor.
And
Thank you, Your Honor.
one last thing. The order says in it that the adversary will be immediately dismissed. So in the party's view, you're not going to be filing anything else. You're just asking the clerk to dismiss your case based on this order?
I'll allow Mr. Razingas to answer that.
Yes, Your Honor. We'd like the clerk to just dismiss him.
Okay. I'll make that instruction note then. All right. Thank you for coming in.
Thank you, Your Honor.
Schnitzel Ninja.
So there we have that. There we have that. There's the audio from the bankruptcy thing. And now let's go to what also happened. So much has happened. So much has happened. This is the audio video from the complex case management conference that took place just a few days ago. Just a few days ago. And as Desperate Freya says, nothing out of the ordinary in the hearing. No, it was quite procedural. As good hearings are, they're technically boring, right? Although I did find it interesting. It was so much of it is interesting, and I overuse that word because it's all interesting. That they did have to confirm signature differences with Laura because I don't know, maybe we can't do things right, and we e-signature one and use a real pen for the other, and I don't know why we can't do things easily. I guess whatever. On to the complex case hearing, and there is video, which we like video. Again, we thank Schnitzel Ninja for all of the FOIA-able, is that a word? FOIA-able requests. Yes. Like the judge said, please no inappropriate audio recording, but Schnitzel is the queen master, I think, of getting FOIA'd recordings and documents and video. So I'm confident to say this was all good stuff, appropriated properly. All right, now to the complex case management conference for Laura Owens criminal trial hearing stuff, things. May 20th. Here we go.
Schnitzel Ninja.
This is CR 2025-007905, State versus Laura Owens. Time set for a complex case management conference. Can I get appearances, please?
Good morning, Your Honor. Erin Petticone for Ed Leiter for the state. Victims Counsel is also present, as is a victim advocate.
All right, thank you.
Good morning, Judge. Christian Leaders on behalf of Laura Owens, who is present out of custody with me at the podium.
All right, and Ms. Owens, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
All right, thank you. I did get the complex case management report. Thank you for that. Counsel, anything that you wanted to discuss today outside of what was mentioned in the report?
Just had a conversation with Ms. Petticone. It looks like we are going to try to set this for a possible change of plea, complex case management conference, status conference, and we're hoping that the court has availability on June 26th.
Probably. Are we in business on June 26th?
In the afternoon only. We have a 9, 10, and 11 in the morning.
Oh, is that a Friday?
It is a Friday.
I mean, I usually don't. I kind of save Fridays for bigger deals. Just more complicated matters, not to be.
he saves part of a day for bigger things than Laura Owens. Probably more like large capital cases, I would imagine. You know, the heavy stuff like homicides and murders and that sort of thing. No, I'm sure that's something they have to do because there's enough of that nonsense. But I find it funny we have to explain it.
Disrespectful, but no, does it take longer than
understood? What about the 25th, the day before?
It should probably work. We good on the 25th?
Yeah, it's a pretty packed.
I don't know that we're going to be doing well.
22 hours.
Can I have one moment, Your Honor?
Yeah.
Did you check Monday the 29th for us?
29th is good.
Okay.
8:40.
Thank you.
Okay, so we'll set this for a complex case management conference and possible change of plea on June 29th. Is there anything the state wanted to talk about today?
No, Your Honor. I did have a discussion with defense counsel about extending the plea deadline, considering that he is relatively new to the case and there have been some relatively minor issues transmitting discovery. The current expiration date is June 26th.
The plea cutoff is June 26th?
It is, but understanding that we're not coming until the 29th, my notes to Mr. Leiter will reflect that.
All right. So I assume he'll move it a couple days.
Yeah, we're not going to use those extra couple days as any kind of leverage timing wise. We will have everything, I think, done and decided one way or another about the plea prior to the 26th. So I'll put that on the record that we're not expecting. I'll have a conversation with Mr. Leiter and we'll straighten this out.
All right. If there's any kind of problem and there's no flexibility, let me know and we'll work out something for you.
Will do. Thank you, Judge.
Okay. So Ms. Owens, you need to be back in my courtroom June 29th at 8:45. And after that, you have that final trial management conference July 22nd at 8:45, then trial assignment July 29th, which is at 9:00. That's before the trial assignment judge. 5th floor of this building, courtroom 5B. If you fail to appear, warrants can issue for your arrest. If you don't show up for trial, it could occur in your absence. Stay in touch with your lawyer. See you on the 29th.
Thank you.
Thank you, Judge.
Schnitzel Ninja.
Ooh. So things are brewing. Things are brewing in the criminal case, folks. And as I see you're saying in chat, there's something going on. Tony Marie says her attorney has set the stage to ask for the trial to be postponed because he's not ready. Yeah, despite what he said earlier in court, there is a move for that to happen. Let's read some documents. You know, it's funny because he says he hopes for a change of plea on that next date on the 29th. Obviously, if someone was going to take a plea, they would have taken it already, right? Right? I mean, can we all agree on that? So what's happening? Someone's not taking a plea. We're kicking the can down the road a little further, shall we say? So yes, I think the presumption that there may be some more delays for the trial is indeed what's going to happen. So we'll read some documents to give further insight because there is some insight going on here. Tony Mirasso says, I think lawyer is stringing her new attorney. I think maybe Laura is stringing her new attorney along, telling him she's probably going to take the plea deal just so he'd announce it at this hearing. So JFC would best that and run with it, then say, psych. We don't know. Well, you know, if she's going to dick around with the no-nonsense court, she'll deserve what she gets. Jen the Couch Fairy, there's no realistic way to get ready for this defense. It's indefensible. It's true. It's true. At least that's my belief, at least. Hello's face and body language didn't agree with Luder's promise to have the plea resolved by the 29th. Notice that, did you, Jen? Very good. Very good. K-Dub says, in my opinion, she will not take the plea. Many of us are there. She won't take the plea. And if she does, it would be last second, and only because things aren't going well. So this little thing, the management report, this is a little bit insightful. Complex case joint case management report, hearing date 5/2026. Defendant's active cases and defendant probation cases, says none. List specific progress made since the last CCMC. Plea agreement proffered. Defense continues to review discovery and collect mitigation. Specific case preparation to be completed before next CCMC. The set settlement conference, and if no resolution, prepare for trial. Witnesses interviewed since last, none. Witnesses interviewed before next proceeding, unknown. Status of and plans for settlement discussions set within the next 30 to 45 days. Status of discovery disclosure, anything outstanding, etc. It says discovery disclosure is complete. However, there is a minor issue with a portion of the disclosure. Defense and state are working to resolve it. We don't get into much more detail than that, so I wonder what the disclosure is. Substantive motions that are contemplated in the anticipated filing, none at this time. And here you go. This is the red bells. The viability of current trial schedule. And I quote, current trial date is unrealistic from the defendant's perspective. Other pending issues to be resolved, not at this time. Victims' rights have been complied with. Yes. And then we've got names of prosecutors, etc., and defense representation. So, folks, watch the gear up to delay trial time. Watch the gear up. We're going to have more stalling with pleas, I suspect. Again, I don't know these factually. These are just my suspicions. We'll see some more fun and games as we get to that plea deadline next month. And then we'll see some other things. And of course, now we've got more house bankruptcy things happening. It's all just a big, it's a shell game. It's a shell game, isn't it? Follow the P underneath the shell. All right, let's see. The CCMC, let's see how these, what is this? The mint notes? Record of pleadings. Oh, okay. So we've got an order here. All right. Aaron Petticone was for the state. Christian Luters, defendant, was present. Record of proceedings is made digitally in lieu of court reporter. Time set for CCMC. Parties filed joint report. Discussion is held regarding the status of case. It is ordered affirming the trial assignment date of 7/29/26 at 9 a.m. before the master calendar assignment judge. The trial assignment hearing is in person for all lawyers and defendants. Parties should contact trial assignment division prior to trial assignment date to request to appear virtually. Well, I think we can imagine what else is going to happen. Purpose of the hearing is to set dates for trial, procedure conference, and jury selection. All self-represented litigants shall appear in person at trial assignment date unless otherwise ordered. Participants and phoning it in, we don't care about that. It is further ordered affirming the final trial management conference on 7/22/26, 8:45 before this division. It is ordered setting a CCMC possible change of plea on 6/29/26 at 8:45 a.m. before this division. Joint case management reports in no less than 2 working days before each case management conference. Parties shall file joint case management report, which informs the court of all the things we've kind of previously read. It's ordered that no time be excluded. Last day remains 8/29/26. It is further ordered affirming prior release orders. Defendant directed to appear, blah, 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 blah. Potential consequences should she fail to appear. Okay, so there's kind of the orders and entries for that. Now, our next item up for bid, folks. Next item up for bid involves a DUI douche canoe. Yay, douche canoe.
The fucking douche canoe.
Oops. Yeah, him. So we have the update. This is, of course, from Seeking Justice for All Victims of Laura Owens at Clayton's Justice on the Twitters. or X if you like it. I don't like calling it X. It sounds like an adult website, so I like to stick with Twitters. And it only makes sense if you're tweeting that it's Twitter. So what are you doing if it's X? It doesn't work. Forget it. Stick with Twitter. The update for the DUI case of David S. Gingras, Dingus the Douche Canoe, a guilty plea, or shall we say a plea deal, was entered for reckless driving while the DUI charge and speeding to avoid a collision were dismissed. It's just sad. Why do I need another sad trombone? But we do. There are no future dates scheduled. The case is over. And this is at Clayton's Justice saying here, it is shameful that the state of Arizona allowed this man arrested for driving under the influence for a second time to avoid the serious consequences he deserves. God forbid he gets in the car again, drunk, and kills someone. Pathetic. I quite agree. So here's the images. Let's see if it opens. There it goes. Count number 1, code charge, reckless driving. Date of violation 7/6/25. Class 2 misdemeanor. Boo. And a guilty plea responsible. The sentence imposed, as far as we know, was that he was charged a fee for the reckless driving of $350. That was his sentence, as best as we know. Isn't that terrible? It's absolutely terrible. Oh, wait. Nope. Maybe there's more. So this is count 2, charge code, DUI, BAC 08 or more, class 1 misdemeanor, dismissed at the request of city attorney, and the presumed fine amount, $1,621.11. Charge 3, or count 3, speed, failure to control speed to avoid a collision. Civil traffic offense dismissed at the request of civil attorney, presumed fine amount. So he got off with a slap on the wrist. He got off with a slap on the wrist. It's terrible. It's terrible that someone can run around with a 0.112 blood alcohol level at the time of their blood draw while they were in custody at the police station. Will be let go with just a little reckless driving charge and a little financial fine. It's outrageous. It's outrageous, and you should all be outraged too. Oh my goodness. Let's see. Change of plea set. Was this for the? I think this is. Yes. Clean improving. Surcharge responded. Yeah, this is all just other stuff for that. All right, that's really not that interesting. So let's go to some of the latest with more douche canoe. More douche canoe coverage. The man is going absolutely insane. He's just having shit fits all over Twitter. He's accusing all kinds of people of being psychopaths and threatening injunctions against Layla of PS Creative Studios. No, wait. Injunctions against harassment. Yeah, he's posting all kinds of shit all over the Twitter. He can't help himself. He's as bad as his client. So he's making all kinds of things, and he's gone so far. Because Hey Rob has filed a bar complaint against Dingus the Douche Canoe.
The fucking Douche Canoe.
We have that. He's posted it all over his blog. It's archived. I'm not necessarily going to share the blog because it's in the archive. So that's fine. But he was taking shots at Rob and Ducky, making all kinds of nasty, rude comments, as Bruce would say, because that's what David Gingras seems to do. That seems to be his only setting. So he was throwing shade at Rob's direction for filing a bar complaint against him. He sort of, I don't know if it was factually or just tongue-in-cheek, says it's bar complaint number 16. But whatever it is, we've got it. We've got the bar complaint filed against him. I have redacted Rob's information because it seems what David likes to do when someone files a bar complaint against him. He likes to publish them publicly so he can dox them. And you know, there it is. We've got all of Rob's information, which I blacked out because I respect the guy enough to do so. It includes his personal address, his phone numbers, and all of his contact information, which does not need to be publicly disseminated information for the purposes of discussing a bar complaint. It's only useful for the bar should they need information or have other things to request for the violent of such things. But as he said in his blog, it was not something he even knew about. He had a letter from Jim Lee, who he hates at the bar. What was I going to say? I've totally lost it. I hate that. Oh yes, no, that's not it. Yeah, whatever. Be that as it may. Rob decided to file a thing. David didn't know about it until the bar dismissed it, not saying much that was actionable, apparently. And there we have it. We'll cover that in a second. I see some things brewing in chat. So, Llama, what do you know? Llama says, did you hear his wife died? Whose wife? Dingus? No, that can't be. Give me more information if you would be so kind, Llama. Or if you're feeling frisky, Llama, and you want to jump in the studio, you can tell us more in person. That's fine too. No thanks, MK says what we all want to say when we see strange things.
What?
David's, he wrote a blog. Wait, I just checked that earlier today. Did something happen? Okay. Hold please. Side quest. Holy shit, Llama's not lying, folks. Not that I would think Llama would. Fascinating. I'll go to that in a minute. Or should I just digress myself now? Wow. Okay, it's breaking news. Breaking news from the cubbyhole. Oh my God. All right, I'm reluctant to even do this. I'm reluctant because I don't like going to his blog. Can I just say that? I don't like it. All right, but it looks like bad news. And this is terrible. This is terrible. I haven't read through all of it. I did a very fast skim. So all right, we'll read it as it pertains to the official thing. And this is okay. All right, here we go, folks. From the Gingras Law Office blogs, titled "Goodbye Jane," broken heart emoji. Posted today. So this is very new. This was not on the Law Office blog when I checked before I hopped onto the studio. So this is within the last hour or so. And it reads as follows. And this is the only word for word I want to give David Gingras, because I don't like most of the rest of the other trash he writes, especially when he's being nasty to other people. And he says this is the hardest thing I've ever had to write, except for a private post I did earlier today on Facebook. I wouldn't normally make something like this public, but I have no choice. It's bound to get out sooner or later. If I don't speak now, speculation will become fact. Fair enough. So here's the truth. My wife, Jane Elizabeth Gingras, passed away on May 21st, 2026, after a battle with cancer. Jane was British, born and raised in London, England. We met in Palm Springs in 2005, were friends for 2 years, then started dating in 2007 and got married in 2008. We had no children. Instead, we filled our years with worldwide travel, lots of adventures in, around Arizona and England, Europe, and we later found joy being Aunt Jane and Uncle David to my sister's 3 kids. For all the speculation about us getting divorced, we remained married until her death on Thursday. I guess that means I'm now a widower and will never have to say I'm divorced. I'm not sure one word is any less terrible than the other. Due to the unfathomable loss, I will be offline for the foreseeable future. I cannot think of anything less important than typing boring arguments about the Arizona bar's crusade against me. The really hard part is that Jane had dozens of extremely close friends. You've never met a person more widely loved by everyone around her. I've spent hours on the phone talking to everyone, sharing the sad news, remembering stories of all the fun we had, crying harder than there are words for. The sheer number of friends means I've now had that same conversation so many times I can't bear another call. My head is pounding. All Brits are private by tradition. It's called being discreet. But Jane was exceptionally private, even for a Brit. That's why I never shared anything about her, or at least as little as possible. That was her wish, and I respected it. Now that she's gone, as part of my grieving, I wanted to share a couple photos to give you a sense of who she was. The most beautiful British chick you ever met, who gave up a life dream in London to marry a stupid, rowdy American. Jane became a U.S. citizen, but her blood was always British royal blue. Goodbye, my sweet Jane. Thank you for 18 years and more love and memories than could fit into 18 lifetimes. Until we meet again, love, your heartbroken husband, David. P.S. If they have YouTube, Spotify in heaven, I'm dedicating this song to you. And there's a picture. And this is a same face in an image we looked at that was a reflection of glass. So that was, in fact, his wife in that image we looked at previously. Well, those are some cute pictures of them. And I hope he does. Oh, there she is without the... Okay, there's the real picture, folks. So that was, in fact, her. Well, that's very sad news. Cancer sucks. And despite David being an asshole to absolutely everybody else that's involved in these cases, I will share my condolences. I've lost people in my immediate family to cancer. I was much younger than I am now when that happened, so I understand the loss. And to those who loved this very vivacious-looking lady, our condolences to her family as well. So that's sad news. Sad news indeed. All right, but that does not, however, prevent me from talking about the other things that were indeed still taking place at David's hand. So, you know, grief is a terrible thing. I don't think it excuses David's behavior, because when you're fighting cancer, that's an ongoing battle on top of all the other stuff he was fighting for Laura Owens. That doesn't excuse his poor behavior. It doesn't excuse his awful behavior. It doesn't excuse any of the rest of it. So there's that. But, the loss is real. We'll acknowledge the loss. But we can acknowledge the loss of his loved one while not excusing his poor behavior. I think we can have room for both of those things simultaneously, not go, oh no, he lost somebody, we can't talk about him ever again. No, because he's done some bad things. And he hopefully will pay some more consequences for the bad things he's done as the justice system so sees fit. So, all right, so this is something that Rob filed, as David said, bar complaint number 16. And this is for David Scott Gingras, and there's his bar number, Gingras Law. The nature of the complaint. I respectfully submit this complaint against Attorney David Scott Gingras arising from his conduct during litigation in Maricopa County Superior Court. Attorney David Scott Gingras represented Laura Owens, the plaintiff, in the underlying matter. This complaint is not intended to relitigate the underlying matter, but to address whether counsel's actions complied with the Arizona rules of professional conduct, particularly with respect to candor toward the tribunal, truthfulness in representations, and the presentation of evidence. This complaint arises from Attorney Gingras' simultaneous and overlapping roles as legal advocate and fact witness in proceedings involving the same client and materially identical underlying facts. As detailed in Exhibit A1, Attorney Gingras entered into representation on March 24, became deeply involved in disputed factual matters, acquired and asserted personal knowledge of material facts, submitted a sworn affidavit affirming his ability to testify, continued to act as litigation counsel in the same matter. This conduct raises substantial concerns under a bunch of ER rules. The conduct described below reflects a pattern of misleading presentation of facts, selective use of evidence, and procedural actions that raise substantial ethical concerns. The issues presented are based on documented filings, sworn statements, and contemporaneous records, each of which is cited to specific exhibits for ease of verification. Billing records reflect that respondent began work on January 2026, the same day the injunction, the IAH was issued, demonstrating contemporaneous awareness of the proceeding. Materials demonstrate that respondent continued to act as litigation counsel while asserting personal knowledge of disputed facts sufficient to testify, raising substantial question under ER 17 and 37. And those are the relevant cases: Owens v. Hey Rob, Owens v. Eckerd, Eckerd v. Owens, and State of Arizona v. Owens. Theory of misconduct. The record reflects a pattern in which allegations were advanced without direct supporting evidence of contact, while materials presented to the court appear to have been selectively framed or contextually incomplete, resulting in a potentially misleading narrative presented to the tribunal. Fact background, relevant facts set forth in the exhibit. Key facts include a fee agreement, establishing representation, participation as trial counsel in contested evidentiary hearing, continued representation related in IAH against A. Rob, submission of sworn affidavit February 26. Facts are supported, including fee agreement, billing records, sworn affidavit, court filings, hearing injunctions, participation, blah, 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 blah. Complainant, Hey Rob was a defendant. Complainant Rob, plaintiff Laura Owens. Attorney Gingras represented plaintiff. Court upheld the injunction following a hearing. Specific conduct at issue. Okay, here's some meat. The following conduct is particularly significant when considered in light of respondents' asserted personal knowledge of disputed facts while continuing to act as litigation counsel. Presentation of allegations without supporting evidence of direct contact. Counsel advanced claims suggesting harassment despite the absence of evidence demonstrating direct communication, interaction, or contact. Exhibits reflect no direct contact between parties. Characterization of contact as harassment appears to rely on inference rather than substantiated interaction. Selective use and framing of media evidence. Materials presented appear to have been contextually incomplete or selectively framed. Full context of timing and sequence is not reflected. Exhibit materials suggest alternative interpretations. Procedural conduct affecting fairness of proceedings during the hearing raised concerns regarding fairness and adequate notice. Changes in presentation occurred in a manner that limited the ability to respond. Timing may have materially affected the proceeding. Characterization of lawful public presence. Public presence, including attendance at court proceedings, was characterized in a manner suggesting misconduct. Attendance at public proceedings is lawful. No evidence reflects prohibited interaction. Alleged rule violations, there's a whole bunch of them. Conflict of interest, candor toward tribunal, lawyer as witness. I'll skip through some of the details. Truthfulness of statements to others, misconduct, impact on integrity of proceedings. The overlap between advocacy, evidence development, sworn testimony capacity creates a substantial risk of compromise objectivity, distortion of evidentiary presentation, undermining public confidence in the legal process. Supporting materials referenced in this complaint are provided in SPDF exhibit files. This exhibit file includes the exhibit index and exhibits for ease of reference. Its exhibits corresponding label, blah, 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 blah. Citations, exhibits, request for review. Respectfully request State Bar of Arizona review the enclosed materials and determine whether the conduct described warrants formal investigation and any appropriate disciplinary action. Statements from sworn affidavit. The ethical issue presented raises directly from the response on sworn statements. Relevant excerpt below. That's just the standard form thing that we see. Sworn statement is significant because it affirms personal knowledge of disputed facts while respondent continued to serve as litigation counsel in the same matter. Declaration, I declare a penalty. Okay, yeah, so it's just signed by Hey Rob. All right. So there was that document that David posted the other day on his blog. Not as exciting as I was thinking over. So that's unfortunate. So we're going to switch subjects. But let me check on you a little bit more, chat. How's chat doing? Yeah, let's see. Oh, funny, nothing. Orbital. Okay, interesting. Let's see. Llama says, it's very sad, so young. Fuck cancer. I agree. And even though I despise David and his behavior, fuck cancer. No one should be made to suffer cancer. It's a strange scientific anomaly that we have yet to figure out what causes it, although I've got some theories. Because I know people that work in healthcare. It's wild. Let's see. Laura Miller, 2827, says the paragraph about divorce is a little emoji. And Rachel Taylor, fuck cancer. Yes, indeed. No thanks, MK. Poor Jane. Rest in peace. Michelle says, wow, R.I.P. Mrs. Gingras. Yeah. WTAFF. No thanks, MK says. Who says that? Jane is in a better place, says K Dubs. Gem Girl says, funny, nothing about an obit online. Well, we'll see. It might be a little soon. Deb Peterson, cancer is so insipid, terrible. Minnie T says she was in Europe somewhere with her mom, I thought. Nice of David to go be there for her. It's interesting, isn't it, Minnie T? Yeah. I hate to be a conspiracy theorist, but I'm thinking it. And you can probably imagine what I'm thinking. Someone else used cancer in their relationship to try and, accuse of things, which is a strange tactic, but yeah. It's suspicious. It's a little suspicious for me. Robin says, oh gosh, she was really young. Wallace says, weird grief response in a couple of different ways, but fair, she deserves respect. R.I.P. to Jane. Jen asks, how long was she back in London? And he wasn't with her? ? Yeah, that's confusing to me. I might have to do some research on that, because it's not impossible to see if there are UK obituaries to confirm that. Linguini. Hi, Linguini. Nice to see you. Very sad. Yes, it is. If it, should it be true, and I hope it's true, I would hope to God that David would not be so awful of a person as to manufacture a cancer death. That would make him worse than Laura in so many ways. I really hope that would not be something he would even remotely consider. And unless proven otherwise, I'm going to trust that his declaration is true and factual. Albeit it may be a little bit odd of an exclamation of loss. Becca. Hi, Becca. YouTube is slipping. I did get a notification. I know, Becca, sometimes it happens. Because to quote Megan Fox, YouTube is assho. So sometimes that happens. No, thanks, MK says, glad she was home with her people. Yeah. Let's see. Jen the Couch Fairy. Who filed that? That was Hey Rob filing a bar complaint against David Gingras. That's what we just read. Not all that interesting, not all that substantive. So I can't be surprised that they decided to dismiss that. Wallace says, yes, absolutely. I have total empathy for David that he lost someone far too young to go. Hi, Jupiter Janes. Hi, Sarah. How you doing? Clap, clap, clap. Danny says, makes me question the way he was spending his last days with her. Yeah, doesn't it, though? Let's just get into Twitter fights and tirades and blog rants rather than spending. It's odd. It's questionable, isn't it? It's very odd. Becca says he was dealing with the DUI charges, can't leave the country. Yeah. Yes and no. Yes and no. With the DUI, David did have representation. As you know, he went to spend time with his father in California, and he didn't even know there was a hearing for something. And he also talked about Laura having a hard day to go into court herself. So he actually didn't appear personally for one of his for the last hearing. It was, I believe, just as his attorney representing him. So he wasn't at everything himself. It raises more questions for me, actually. Yes, that was Rob's filing for David. Ms. Wing says Echoes needs a Canadian flag, but I'm not Canadian. I'm not. I'm far more British than I'm Canadian, believe me. Misdemeanor charges do not prevent you from leaving the country. Let's see. Becca also says it's one thing to petition to visit a neighboring state, something else entirely to leave the country for an unknown amount of time. Yeah, but not without good cause. At least in David's case, I would think. Any judge would have let him go. Did he even try? Yeah. The DUI was struck down. It was dismissed to become reckless driving. So they didn't pursue their charges of DUI with a BAC of over 0.08. Even though he had a BAC, according to blood analysis, of 0.11, 0.112. They decided not to pursue those charges for God knows what reason. Ducky says, that is sad. I wouldn't wish anything like that on him or his wife. Yeah, exactly. And that's where I can have a little shred of empathy for David, but that's where it ends. It really is. He's done so many horrible, despicable things, wishing death on absolutely everybody else, and wishing worse than death on some other people, including the wives of other content creators, that, I'll be honest, I'm a little bit conflicted having empathy for him. So there's that. I mean, I'm just being honest, because that's all I've got. It's hard for me to have that after he did such nasty things, but I will. I'll give just that little shred of empathy for that. Sarah Jupiter Jane says, I'm thinking he could have requested permission if he wasn't allowed, especially under the circumstances. I would think so too. Very sad. End cancer is so ugly. Sad, hopefully honest if telling the story. Why wouldn't he hold her hand? Yeah, for sure. Michelle says, honestly, maybe she didn't want him there, and maybe he respected that, which, I mean, God. Hello, there's more red flags. Let's see. No thanks, MK says, empathy for Jane doesn't equal zero accountability for Jinky. Yes, amen. Ducky says, right, she and him may not have been on the chart, but doesn't still love her, and he was married to her for quite a while. Anyways, still hear that, yeah. Texas Packet, hi, Tex. Good to see you, saying to Wallace, I just want my old Dutch dill pickle and ketchup chips back. Oh, the chips. I just tried a new bag of chips from the Trader Joe's, an Irish garlic butter potato chips. Yeah, those went a little too quickly. Danny says, I'd be tempted to ask him if he still wishes evil on other people's wives. As tempted as I would be to poke at him, Danny. Other people have no problem poking at David. I'm a lot more reserved in that regard because, frankly, I don't want to talk to the guy. What little I say in reference to him on Twitter is more than enough for my stomach. So I don't want to talk to him. I don't want to have conversations with him because I don't think he's trustworthy. I don't think he discusses things in good faith. I think he's got a lot of problems that I believe he needs to get a lot of help for, and like Laura Owens, chooses not to. I'm an adult. You can't make me. It just becomes defiance behavior. Dana also says, let's see, forgive. Can't imagine hanging with him that many years and ghosting at the end. Yeah, it does seem a little odd, doesn't it? Half-Ass Fashion says, going through cancer, I learned who my real friends are. I'm so fortunate to have them and make it through. Yeah, indeed. Anybody, oh gosh, Llama's dropping more breaking news here. A new Laura email. How so much happened in the last 24 hours. Yeah, well, it's not new. It's old, Llama. This is actually old stuff, but we'll pretend it's new because it's the first time we've seen a little more to this story. Danny says, I poke and pretend land. These are thoughts that live in my head. And the cubbyhole. Yeah, well, this is why I share my thoughts outside the cubbyhole. Serving piping hot tea. Face pink drink. Llama's with it. Let me tell you, Llama is on the ball and then some. Two texts from Wallace. Let's get you a care package. Chips are light and Old Dutch is one of the cheapest brands out there. I don't see Old Dutch chips. I've not heard of that one. That's new to me. Pretend it's new for Llama. LOL, we will. Well, it is new. It's new for all of us because it's part of an old story that we didn't have all the pieces to. So I will actually start at the beginning. And this again is from Justice for Clayton Reddit. And then I'll go to the actual documents because we have the actual documents and we like documents. And it says we have a brand new, never before seen piece of the puzzle regarding Laura Owens' attempt to contact the court, her ex parte communications behind the closed doors. While the community is familiar with the initial ex parte email and the court's subsequent shutdown, this follow-up email has never been made public until today. It's posted earlier by Volo, blah, 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 blah. And we'll go into that. And this is about the Gillespie case. So this is all about Greg Gillespie. I won't read all this because we've got actual documents. So let's switch. And we'll we'll engage in some readers' theater. We must have a little levity in reading some of this nonsense. So let's say I need to push some buttons. We've got buttons to push. No, not that one. Got to get on the right page here. Okay. Let's go that one. Oh, and I need another button. You need more buttons. Let's see that page. Let's do this. We got to read this in the proper Laura Owens voice. This is stuff you've heard. This is stuff you've heard, and this is stuff you've seen. But we've got to get context, so we'll back up a little bit. We'll be historic. We'll cover what happened. We'll go chronologic, and then we'll get to the new item that's with this one. So here we are. Yes, indeed.
Hi, Marlene. I hate to email you again, but there is a major issue with the defendant, Mr. Gregory Gillespie, and his attorney, Mr. Greg Woodnick, that needs to be brought to Judge Bacchus's attention privately before she rules on the motion to extend, filed by my now former attorney, Carrie Ramos, as I have. On March 4th, 2022, I was drugged, violently assaulted, and raped. I have strong reasons to believe that both the defendant and his counsel were involved, and there's a pending FBI investigation regarding the incident. To my knowledge, neither the defendant nor his counsel are aware that they are being looked into. I was worried that submitting a motion ex parte could accidentally be publicly e-filed and accessed by them, which would pose a threat to my safety. I apologize for sending an email, but I could not think of any other way to alert Judge Bacchus about this without giving the other side confidential information about what has transpired. I have an order of protection against Mr. Gillespie, which was issued on November 12, 2021, and was uncontested. Just weeks prior to that, another woman, redacted, was granted an order of protection against him as well. When my pregnancy was confirmed to him directly by one medical Kirland, the nurse practitioner was concerned enough about his reaction to it that she requested to speak to me alone about whether or not I felt safe and notated it.
Just a little insert. That's not how those things work with medical professionals and the reporting of concerning things. You know, medical professionals are mandated reporters. So already, if you don't know this story, this is bullshit. This is a bullshit story. Yeah.
On March 4th, 2022, just hours before I was nearly killed in the incident described above, I received an unexpected email from Mr. Woodnick. Without a subpoena, he had somehow obtained the complete 221-page case file of the CLETS restraining order against my ex-boyfriend in San Francisco, Mr. Michael Marraccini, that has been in place since 2018. Mr. Woodnick should not have been able to access that file, part of which was confidential, without involving Mr. Marraccini. Mr. Gillespie was aware of the fact that Mr. Marraccini's physical abuse caused me to have brain damage, which resulted in me developing epilepsy at the age of 27.
Bullshit!
Mr. Woodnick knowingly connected the two men I have protective orders against, Mr. Gillespie and Mr. Marraccini, which has left me terrified.
Bullshit!
My now former attorney, Miss Carrie Ramos, was aware of the events of March 4th and their possible involvement since before she filed into the case. I reported Miss Ramos to the Arizona bar on June 13th after she filed a motion to withdraw from the case after I told her that I had recorded a phone call with her where she said that she totally could have filed an amended answer to the second motion to dismiss, motion for judgment on the pleadings to correct her error in filing responding to the first motion to dismiss filed on September 21. Rather than the second motion to dismiss.
There's so much crap. There's so much crap.
In addition to the more clear potential violations. Potential. How's that for a non-committal word? There is reason to believe that Ms. Ramos may have colluded with the other side. The Arizona Bar has not completed reviewing the mountain of evidence I provided them with, but I have been in frequent communication with intake counsel Reed Potter, who told me in our last conversation that he was going to speak to Mr. Woodnick. As I have submitted in prior filings, Mr. Woodnick has acted unethically throughout the case, starting with contacting an attorney in California who he knew to be a longtime family friend, Uncle Joe Cotchett, and claimed that he believed him to be representing me in a Title 25 case in an effort to embarrass me. That clearly was not what I filed in CV 2021-blah blah blah blah. And divulging information regarding my pregnancy to Mr. Cotchett was horrifying, especially since Mr. Gillespie knew that Mr. Cotchett was representing my father in a severance case at the time. Despite Mr. Cotchett writing a one-sentence email back saying that he did not represent me, Mr. Woodnick sent 4 additional emails without a response in a bizarre attempt to frame me for fraud, demanding that Mr. Cotchett spoke to me about dropping the case.
Really? Really? We have to have a leaf blower or weed eater outside now? Really? My God. I've got such rude neighbors. It's ruining my flow. I just hear grrr, 2-cycle engine noise. I'm so distracted. It's gonna ruin Devil Laura Owens' voice. Oh, it's terrible. Whatever are we gonna do? Go away. Go on. Get out of here. My windows are open. We need the fresh air. It's okay. It's fine. If it gets through demon voice, that's just the way it is. It'll add more spookiness to the background noises.
Mr. Woodnick even emailed me saying that he was unsure that my Uncle Joe, a nickname for Mr. Cotchett, had warned me that Mr. Gillespie would be filing a counter petition for a fraudulent ultrasound if I did not immediately file a motion to dismiss. Mr. Woodnick never received a call from or had a conversation with Mr. Cotchett, so this was pure intimidation to get me to drop the case, based on an exchange that never took place.
Let's just point out that there's documentation that Woodnick did in fact call Cotchett, Petrie, and whatever, the actual law firm, and have a real conversation. This is Laura Owens lying out her hoo-ha. Laura Owens is lying out her hoo-ha right here. Because we have the filings. We've read them, we've talked about them.
Mr. Cotchett gave permission for me to share a note with the court that he sent me on September 30. Quote, "It is an extraordinary story with Gillespie. I am glad you are pursuing charges as they conduct is outrageous. If we can help in any way, do not hesitate to call." End quote. Despite the offer, I have declined help from Mr. Cotchett, as I would never ask a California attorney who is not licensed in Arizona to help me. As proven simply in his filings on behalf of Mr. Gillespie, Mr. Woodnick has taken every opportunity to insult my character with cruel personal attacks. In addition, despite not having a scheduling order, Mr. Woodnick has demanded disclosures and answers to interrogatories, which I provided to Ms. Ramos in a 45-page document on March 28th. While I was under the impression that she had submitted these to Mr. Woodnick on April 8th, I am guessing at this point that she did not, since he has threatened to file a motion to compel against me if I do not provide them immediately. At this point, if he does not already have them, I do not want to give them any confidential information that could jeopardize my safety. The order of protection has done nothing but keep Mr. Gillespie from stalking and harass me, And despite Mr. Woodnick being warned that his unethical behavior would be reported, his intimidation has persisted. Their actions have been frightening enough for me to make the decision to leave Arizona permanently.
Oh,
wouldn't that be bad?
Wouldn't that be terrible? Oops, I'm hitting more buttons. Wouldn't that be awful if she just decided to leave Arizona permanently? No, she decided to engage another scam and fraud with Clayton first, allegedly. Well, it was a fraud. Her pregnancy thing was a fraud. It's not alleged. It is. That was it's a point of law. It's adjudicated fact by family court. Nothing alleged about that fraud. Nothing alleged about the pregnancy fraud at all, which gave rise to 14 felony criminal indictments. Oh, let's see. Oh, we're not done yet. It's Laura. It's Laura, just like David. It's Laura. It's going to go on for pages.
Despite Ms. Ramos's withdrawal, Mr. Woodnick has made it clear to the court that he does not want to allow an extension for the oral hearing scheduled for August 11, as evidenced in his response. The attorney I have been speaking to about representing me, Mr. Jason Vendetti, is going to be out of town that day. Both he and Mr. Potter said that regardless, it would be virtually impossible for any attorney to catch up by then and be appropriately prepared to defend a constitutional issue. Ms. Ramos did not want me to tell the court about anything related to the criminal aspects of this case. But now that I am unrepresented and scheduled to represent myself at the oral hearing, I know that I have to. I simply can't explain to Judge Bacchus why her granting the motion to extend is so necessary without explaining what is going on behind the scenes, and other than an email, I didn't know how to get this message to her. I truly apologize if this is not the proper way to inform her, but I hope that both she and you understand the degree of panic I feel at the idea of facing Mr. Woodnick unrepresented, and pray that she will take into account my justified safety concerns in her ruling on the motion to extend. Thank you.
All the best!
Laura Owens. Laura Michelle Owens, co-host of the Nobody Told Me podcast, CEO of Quartet Farms. Watch my TEDx talk, the most watched new American TEDx talk released in January 22, without our self-promotional bullshit at the end of an email. God, it makes me sick. Makes me sick. Okay, it's time for a change of DJ here. All right, here's the next tidbit in this. Let's see, make sure I do this in order. This comes as a response to that previous email from Marlene Hovorka, who I think is maybe a clerk, judicial assistant to the Honorable Allison Bacchus. So that's who this is from. And it says, Miss Owens, ex parte communication with the court is not allowed. I am copying opposing counsel on this email so that counsel is aware of what I'm telling you. This email address is for informational purposes only. If you want to provide the judge with substantive information regarding your case, you must do so in accordance with the rules. Best regards, Marlene, judicial assistant. All right, so now to the new part. To the new part we have not before seen. Laura's response to the response. So we have more, because how can we not, right? From Laura Owens.
Hey, Clayton.
No, I'm kidding. It's not Hey, Clayton. But it would be funny, wouldn't it?
Hi. Could you please clarify which email you were referring to when you said that you had sent this email to opposing counsel? Did you include my email in which I expressed fears for my safety pertaining to the defendant and his counsel? It looks to me like the email was included in the email that was CC'd to Miss Bowman. I'm extremely concerned, and I hope I'm wrong, because if they are aware of the information I divulged in that email, I truly believe that I am in grave danger and do not know what to do to remain safe.
The best.
Laura Owens, co-host of the Nobody Told Me podcast, co-CEO of Quartet Farms. Watch my TEDx talk, the most watched new American TEDx talk released in January 2022. Oh my God. Oh my God. Oh my God. It's just wild. Absolutely wild. All right, let's see. How you doing, chat? How you doing? We're kind of at the end of things I had on my table dished up on the plates for today. Let's see. I probably should catch up a little bit. I'm behind. I'm behind. All right, that's enough. That's enough of the background music. We don't need more of that. Let's see. Sarah says, I can't believe how nuts this is. Well, actually, I can. Yeah, I know. Tony Marie says, exactly. Pollution. Cheetos, and tell the court of all the email. She sent Greg Gillespie about her uncle, Joe representing her. She's so full of shit. Yeah, well, I think she's full of horse shit, among other things. TX says, but then you think for 5 seconds and you can believe it, can't you? Yeah. Don't think too long. It will hurt. It will hurt. It's what her hoo-ha does best, allegedly, says Batty McBatface. Oh. No thanks says, oh wait, not banjos. I've got a Bella Fleck in the car right now. Dueling fiddles. That would be funny. Intel's on Laura, even after this bullshit email to the courts, keep writing Woodnick about if Greg changes his mind, she'll drop the charges. Bruce the Moose says, narrator. Wait, where's my narrator button? Damn it. Narrator, she did not leave Arizona permanently. Unfortunately. That's too bad. Clean up on aisle 2. Laura Owens. Let's see. Jim Grohl says, one thing I used to say about my ex, he would lie even if the truth was better. There are those people. She is citing her fake emails with Cotchett in her email to the court. That's what it seems. Bruce says, cool. I thought she was the manager or the face of the parental company. Maybe only after the cool sculpting. We don't really know. Bruce also says, I guess when you market yourself as an entrepreneur, you can call yourself whatever you want. Well, she does a little more than that, though, doesn't she? Turdata says, now wait, all of this is actually Greg. He hacked her email. Oh, I know. There's more Greg hacking. Michelle says, ooh, that was creepy. Wallace TX. That's okay. We can skip that one. Oh, let's see. Michelle says, Bruce, I'm marketing myself as a love. Be sure to let Lauren know. Lauren likes the loves. Although Hellville here is already left to go meet up with Lauren, so we can't talk about loves in person, I suppose. Oh, no. Nobody wants to touch you, girl. You're good. Says no thanks. Okay. Let's see what else we got. She's so scared yet never called the local police. Yeah, she calls the local police on all the mean things people say about her online. That's all she seems to call the police for. They're talking about me on the internet, and I want you to arrest them. Ramos realized her client was insane and ran the hell away. That could be. Ducky says, Bacon's way of saying Hoboken reminds me of the sisters on Simpsons. Oh, golly. Oh, I'd have to think about that one a minute. It's been a while. Tony Marie says, sorry, I'm not crazy, but my voice to text is. That's why I don't use it. It says weird things. Turdadder says the FBI investigation is still underway, right? It's still pending. Yes. All things are still ongoing for Laura Owens. Of course. Of course things are still ongoing for Laura Owens. It will be that till the very end. I mean, it's just... what else can it be? What else can it be? Oh, backing up even further. Jennifer C. says, okay, we really need to get Bacon Bears and Echoes together to have a Laura Demon Voice contest. That sounds like fun. Well, you never know. Some of us plan on participating in Llama and Buffy's Marraccini money-raising fundraiser extravaganza happening, I think, June 13th. That's a Saturday. Damn it, I don't have the media sitting here. Otherwise, I'd bring it up. So I trust at some point Bacon will make an appearance. I think many of us will. I'm not quite sure everybody who's participating that Llama has got involved, but it sounds like quite a crowd from what I gather. Oops, golly, hit the wrong buttons already. That works. I don't care. So I think there's going to be quite a full rotating panel of people over a 12-hour span for Llama's True Crime and Wine Time Money Marathon for Marraccini. So mark it on your calendars, folks. June 13th is the current date. I can't imagine that would change, but it's Llama's show, and we are just going to participate. And with any luck, I might last the whole thing. Wow, Llama says, that's what I'm working on now. 25 guests confirmed and more on the way. Oh, my God. God bless you, Llama. That's incredible. A little bird has suggested to me there will be some big names that show up to that. So mark on your calendars, 12-hour marathon. If I'm not mistaken, Llama, correct me if I get it wrong. 12 p.m. Eastern to 12 a.m. on the 13th, starting on the 13th at 12 p.m. Eastern time for a full 12-hour marathon to raise monies for the mic. And it's going to be wild. It's going to be wild. Including, Llama says, including people who have never been on the screen but are well known in the community. Ooh, I've heard about some of them too. Not everybody wants to be on screen, but to those who want to jump in and be a part of the hoopla, more power to them, because that's amazing. And damn it, I closed it. When I last checked the GoFundMe for Mike, it was sitting at 84,000 and change. So there's still room. There is still room to contribute. You may contribute here. You may contribute later, because there's going to be not only wonderful donations and contributions from the people watching and listening and participating, but there will also be stuff being auctioned off. So it's going to be a wild, fun block party of a time, and I'm excited. It's on my calendar. I can't help it. What else am I going to do? And with any luck, I'll try and hold on for as long as I can, because it sits in a convenient-ish time for me. It's not so late, but it would be a full 12-hour day for me. But I would like to be part of the majority of it, unless Alma decides, it's like, okay, buddy, we've seen enough of your face. Get out of here so other people can be on screen. Because, there is technology limitations. Not everybody's available at the same times, but I'd love to be part of the whole thing as much as I can and as much as I'm allowed to. So there's all that goodness waiting for you June 13. And I'm sure more will come out as Llama decides to share it and has it all put together. But kudos to Llama and Buffy and everybody at True Crime and Wine Time for constructing that. And I hope there will be some people who you also are on screen that I've not, been allowed to participate with. So hopefully we can, sort of a virtual meetup before we all converge on Arizona at some point in time, either real or virtually. So it'd be nice, then I could actually say hi to people on camera for a change. And okay, Megan Fox, you're not getting away from me that easy. I'm going to say hello to you, whether you like it or not. I'm being silly. All right. But otherwise, folks, let's see. Is that everything? Yep. Just going through my list, checking it twice. Yeah, that's all I got for you folks today. And see, without Jeep Daddy, it doesn't take 4 hours to do it. See, See, I can be so efficient. Don't tell him I said that because he'll give me some sort of smart ass, snarky, evil response back, and then I'll have to put up with it later. So, thanks for joining me on this holiday weekend afternoon and evening. And OK Dub says I'm not allowed in my neighborhood app. That's okay. I don't like my neighborhood app either. I got off of it. Some people tried to get me booted from the neighborhood app, and I said, "Oh, this isn't worth it." You know, there's those silly things like Nextdoor, and I'm not sure what the point is because you get self-righteous moderators that don't let you share concerns about your community. That's stupid. But anyhow, thanks again, everybody, for joining me for this little foray into all the stuff we've covered. Again, all the details are down below. Be sure to hit that like and subscribe, hit the notification bell. For the replay crew, please and thank you. Hit the hype button as well. I should have said that on the front end, but I forgot. But until next time, folks, you know, it'll happen. There will be more, and we'll be keeping an eye on it, especially as things unfold with the latest bankruptcy nonsense with moms and dadums. So until then, everybody, bye.